Is there a RESPA issue, state or nationally, that industry hasn't really paid enough attention to?
The one that I talk to folks about a lot now, which sometimes kind of blows my mind, employing real estate agents, either at lenders or even at title entities. And there seems to be this idea that because FHA relaxed some of their conflict of interest guidelines a year or so ago, that now these employment scenarios are perfectly fine. And while there is an exception to pay employees for referral activities, those people have to be bona fide employees. And that really requires a deep dive into the facts and even into the state law and how they define employment relationships.
Welcome back to Keys to Real Estate. Last time we talked about what's happening or not happening at the federal level when it comes to RESPA enforcement. And one of the big takeaways was that when the federal government pulls back, something else tends to happen. The states step in. And that's exactly what we're seeing right now. So in this episode, we're going to drill down into state level activity, where enforcement is picking up. We look at what regulators are focusing on and why some of these interpretations are catching people off guard. I'm joined again by Holly Bunting, partner at Mayer Brown, who has dialed right in on these developments and has been working through them in real time with her clients. Episode 1 was about understanding the broader landscape, and today's conversation is about where things are actively moving and what you need to be paying attention to right now. Presenting sponsor for this season of Keys to Real Estate is First American Trust. First American Trust redefines banking for title and escrow companies. They offer innovative solutions that integrate banking functions directly into title and escrow software systems, enhancing operational efficiency and safeguarding financial transactions. At First American Trust, you have direct access to a personal relationship manager who delivers answers in real time. First American Trust is also recognized as an elite provider for the American Land Title Association. As a wholly owned subsidiary of First American Financial Corporation, they have roots in real estate tracing back over 135 years and is the only bank owned by a title company. With deep roots, advanced solutions, and a commitment to real relationships, they are setting a new standard for the industry. The future of banking for title and escrow starts with First American Trust. Visit firstamtrust.com to learn more. Holly Bunting, welcome back to Keys to Real Estate.
Thank you. It's great to be here.
Well, last time we really talked about the federal enforcement landscape, and now we're going to drill down into the states because there's some real interesting things happening there. Seems like they're stepping in to fill in the gap a little bit. Let's talk about generally, what are you seeing?
Exactly what you said, stepping in to fill the gap. And I think that's often what we see when there's a pullback at the federal level. From an enforcement perspective, we see states sort of pick up and fill that gap. And I think the Mid-Atlantic region right now has really sort of been pretty active. The attorney generals in DC and Maryland have both issued settlement agreements as it relates to joint ventures. The attorney general in Pennsylvania has filed suit as it relates to a mortgage joint venture. And I've heard folks say that now that the Virginia attorney general is a Democrat, that we may see Virginia take up these issues as well. But those states have all consistently focused on joint ventures, title insurance, and mortgage joint ventures that have individual real estate agents, owners in those businesses. I was involved in a couple of the matters in DC, and the attorney general really did focus on RESPA, at least in terms of the back and forth and the types of issues that they raised or took issue with. Ultimately, those settlements ended up only being based on DC law. DC's title insurance law includes a very broad prohibition on consideration for referrals. And it was the attorney general's interpretation that that meant there's no exception for affiliated businesses. It doesn't matter that there's one that exists at the RESPA level. State law can be more restrictive, and they interpret their state law as essentially not permitting joint ventures. Never mind that that's pretty inconsistent with the way that they view brokerage-owned joint ventures as not in violation, or at least not targeted for enforcement. But their position really was, in these situations where title agencies have started, you've got multiple individual agents that buy in as owners of that business. I mean, let's say they're buying 2%, right? based on the total capitalization of that business, they may only need to contribute $2,000. And if that business is successful, their return is going to be substantially more than that. And at the end of the day, I think that's what the DC regulator didn't like, is that the return on the investment was substantial. And that led them to then allege that the amount of contribution that these individual agents made was discounted, that they weren't required to put in an amount of capital that was commensurate with what their return would be. And Pennsylvania has sort of been on the same theory, and they've advanced this idea that you should really be looking at what it takes to price an IPO in order to determine what a real estate agent is supposed to contribute, right? Completely novel, not based in any statute, reg, guidance document that's ever been issued as it relates to RESPA and joint ventures. In fact, the only thing that exists from a guidance perspective is that the entity should be sufficiently capitalized to operate the business. Well, I mean, folks do the work to figure out what their expenses look like, and they project capital based on being able to operate that business for 6 months with no income. And if you have multiple owners, yes, that means that the price to buy in may not be significant. So we could talk all day.
Yes.
About that particular issue and why I do not think it's grounded in the law or the guidance. But nonetheless, this often happens when states get involved. It's not their interpretations they're having to follow. They'll look at factual scenarios and I think create their own interpretations and advance those from a consumer protection angle. And that's, I think, what we're seeing.
Okay, on one hand, it sounds like if your business is successful, it's a RESPA violation. I mean, long and short, which is kind of what some states did a million years ago. Well, if your marketing efforts pay off, if it results in increased business, then it's a violation. It's not exactly new scenario, new application, novel, but we've kind of seen that line of thinking before. But I'm wondering, however, we have so many agents who are telling us that this is impacting their bottom line. Now, it's anecdotal at this point, but from 2 years ago, where this was really only kind of happening in a couple of markets, one of them very notoriously not regulated with regard to title premiums, which I think has a bearing. But if we're suddenly seeing a lot of complaining from title agents that these have become a problem in their market, I guess you could argue that there is maybe less competition, ? Or is it just hey, this is a program that is successfully working? I mean, title companies have worked on having relationships with realtors for years because they are that front line and they are that trusted advisor for consumers. So is there a way to parse that logic, or are we just in a big we don't know land?
That's certainly the concern that the attorney generals are expressing, which is we think consumers have less choice. We think that they're being steered because, this agent has this financial benefit. RESPA in many ways recognizes that and requires the affiliated business disclosure, right? So it's not like consumers don't know about the affiliation and have the opportunity to make the choice. That said, I think that the assumption that folks enter into these strictly as a money-making venture doesn't recognize the fact that if a transaction doesn't close, if that business doesn't provide good service and check all the boxes, dot the I's, cross the T's, and get that deal to closing, the agent's not coming back there, regardless of whether they have an ownership interest or not. And so at the end of the day, I truly believe that is the motivator. I mean, sure, there's bad actors, right? There's folks that are just not in it for the right reasons. I feel like that's a dating show line, but nonetheless,
all the right reasons. Yeah.
At the end of the day, if the deal doesn't close, nobody makes money. So in the creation of these joint ventures, it has to be done, of course, compliantly. Folks are entitled to earn their profits as long as that business complies with the RESPA requirements. And ultimately, the business has to come through for the consumer and for the owners and make sure that it's providing good service and getting deals done. Yeah, maybe there is an impact on folks' bottom line in terms of the amount of distributions because folks are a bit concerned about entering into these ventures or at least opening it up to a large number of individual agent owners. That said, I do think that the focus is on getting the deals done. on. And that's always going to be the number one priority.
Well, and I think it would be harder to find consumer injury in a filed rate state, I would think.
100%. And this is something, even in the RESPA context, that, we harp on when these enforcement matters come up and the U.S. Supreme Court is clear, there must be injury, must be able to prove injury in order for there to be a valid claim. And that's often the question, is where's the injury? In the DC Attorney General matters, there was another company, they were not my client, but they had done some informal survey to try to measure the costs that the companies that were subject to the subpoenas in DC as compared to independent title companies in the area and how those prices compared. Not surprisingly, affiliated businesses were some of the lower priced. Or were sort of right there in the mix, right? And so this idea that the mere fact you're an affiliated business means that you're going to charge higher prices just doesn't play out in reality.
Yeah. Fascinating. I'm going to go back to these states, primarily attorneys general. Do you see any coordination with federal regulators? Are they operating independently, kind of based on their own? Are they talking to each other? Are there some former federals involved? What is the dynamic there?
So I don't know if they are coordinating with the federal government. I would think not. I don't know that they would get a lot of cooperation at this point. So I do think they're a bit on their own. That said, well, I was going to say, I'm sure they're talking to each other. I say that as more of just a phrasing rather than confidently knowing that that's happening. But anytime, particularly given that we seem to be dealing with the mid-Atlantic states that are all bordered by each other, I would expect that they are watching what each other are doing. And the fact that we're seeing very similar allegations made suggests that they are, in fact, talking to each other.
And we've heard, I haven't seen it, but we've heard tell that maybe some of the former CFPB formers might have published or shared a little playbook that maybe the states are looking at.
100%. That was one of the last things the Biden CFPB did. Is they put out sort of a guidance document for the states to use to enforce these particular statutes. I mean, some of the enforcement folks at the CFPB have gone into the state regulator and AG offices as well. I know one former colleague that was at the CFPB is now in the Maryland Attorney General's office. So, folks that were very much involved in the enforcement of the federal consumer protection statutes as an employee of the CFPB or moving to places where they're able to continue that work.
All right. Well, I want to look at what's being enforced or at least looked at in the ABAs. Like is there a clear line today between what like a compliant ABA would look like and something that the state regulators are challenging? We talked about the real estate agents versus brokers a little bit, but what else are you seeing out there in this space?
I mean, marketing arrangements are also, I think, on their radar. There's tons of promotional opportunities and sponsorship opportunities that happen with folks. With the Attorney General in DC, while this wasn't necessarily part of their allegations and their subpoenas, when they entered into these settlements, they took them straight to the local media. And they gave the local media some social media posts of one of the entities hosting a promotional opportunity out at the Chesapeake Bay. And they very much used them in a way to make it look like these types of marketing activities really are just boondoggles meant to shower folks with lavish opportunities. That's an example of where that didn't end up necessarily being what underlied their settlement, but that was what they used to make a splash. And so I think that's a good reminder that that's exactly what they're looking for, right? Is social media posts or marketing flyers or in this case, I think someone had posted video to social media. And they take that as an opportunity to make a splash and sort of shove it into a bit of a argument or allegation from a RESPA perspective. When, if you break it down, those activities fit within the marketing promotional exceptions that the CFPB even provided us FAQs on. So those are still, I think, marketing JVs are always going to be the types of things that catch their attention.
Was that the action that surprised you most recently, or is there another one that surprised you even more? Because that one surprised me quite a bit.
Yeah, having been involved in negotiating these issues and in the back and forth with the DC Attorney General, lots about that surprised me. And folks make business decisions about where to take these matters, even if it's not necessarily reflective of their position or belief as to their compliance with the legal requirements. I would say that one probably has surprised me the most. And again, I do have a little bit inside knowledge there to add to that.
Well, if I'm a national or regional title agent, and up until 5 minutes ago, I was tuned to federal enforcement, gosh, what does my new posture need to look like right now?
So at the end of the day, and this is something I talk to clients a lot about, is the law hasn't changed from a federal perspective. Even individual real estate agents that have ownership in affiliated businesses, I think that's legal under RESPA. But I do think that given the environment in the states right now, before you launch a new one or make drastic changes to those you have now, I would take the temperature in your state. And capitalization, sort of seems to be the issue that rises to the top right now. This idea that if you only contribute $2,000, that's not sufficient. Maybe we need to inflate the capitalization amount a little bit right now until we work through some of these state issues, which again, not required to do that from a legal perspective, but sometimes the enforcement environment kind of forces our hand a little bit to just in an attempt to really take a target off of you in whatever venture you're putting together.
That is really, really good advice. You mentioned last week that, if there's a Democratic administration next time in the White House, that we will probably expect to see enforcement ramp back up at the federal level. I'm wondering, though, in that scenario, which is not for certain, obviously, do you think the states will ramp back down, or do you suspect they might stay comfortable up here and start to get some successes and wins and have their local media support what they're doing for their constituents? I wonder how that might play out.
Yeah, I would think that we'll see more collaboration for certain, where the state AGs who are typically very involved in consumer enforcement, those particular states, I think we'll just see more collaboration with the CFPB. And we've certainly seen that in the past. There were some actions in Maryland brought against title agencies where the CFPB and the Maryland Attorney General were both involved in those. Some of them turned into class actions a little bit after that, but I definitely think we'll see more collaboration. I don't know that they'll pull back. Obviously, folks are at the state level are responding to whatever the priorities are within their states. And so that'll always impact what their activities will look like. But I do think there'll be more collaboration with the federal government.
I think I agree with you. And finally, is there a RESPA issue, state or nationally, that maybe industry hasn't really paid enough attention to, that, like, if you could focus people's eyes on one emerging place right now, what would you point them to? Would it be the real estate agent thing, or would it be something else?
I mean, that's certainly one of them, I think, is looking at real estate agents and how they're involved in joint ventures. Honestly, the one that I talk to folks about a lot now, which sometimes kind of blows my mind a bit, are employing real estate agents, either at lenders or even at title entities. And there seems to be this idea that because FHA relaxed some of their conflict of interest guidelines a year or so ago, that now these employment scenarios are perfectly fine. And so I'd like to remind folks that RESPA has always existed. And while there is an exception to pay employees for referral activities, those people have to be bona fide employees. And that really requires a deep dive into the facts and even into the state law and how they define employment relationships. So that's when I would put on the radar is if someone proposes to hire a real estate agent as an employee, really need to dig into what that means.
Oh, well, we're going to have you back soon to discuss that one in more detail because, I was aware of the relaxation and it cocked one eyebrow, but I thought, okay, but I did not realize that this was a new area of exploration, let's call it.
Yes.
All right. Well, Holly, you always bring just a basket of riches for us. We appreciate you helping us know how to think about some of these things and how to approach them. Obviously, everyone, Holly's information, should you need a RESPA of your own, is linked in today's show notes. As you can tell, she's always got fantastic information for you and will help you stay on the right side of things. Holly, thank you so much.
You're very welcome.
One of the themes that really comes through in this conversation is that the rules themselves may not have changed, but how they're being interpreted and enforced certainly has. And at the state level, that can mean new theories, new scrutiny, and in some cases, a very different risk profile depending on where you operate. So whether it's joint venture structures, marketing arrangements, or even emerging issues like employing real estate agents, this is an environment where it pays to stay informed and to think a step ahead. Holly, as always, brings clarity to a space that doesn't always offer a lot of it, and we're grateful for her time and insight. If you'd like to connect with Holly or learn more, we've included her information in today's show notes. And if you found this conversation helpful, take a moment to like, subscribe, or leave a comment. We always appreciate hearing what's resonating with you and what you'd like us to cover next. And as always, thanks for joining us on Keys to Real Estate. We'll see you next time.